Okay, ladies and gentlemen, we will move to the second session this afternoon. And in the the topic of the second session is investment disputes resolution. And everyone knows that investment disputes resolution is a very hot issue in recent years. And it's even hot than the WTO trade issues. I remember after China acceded to WTO, trade issues very, very hot in China. But in recent years, even China has moved to the investment issues from the WTO, since someone said WTO is dead, right? Because the new round of negotiation now meet a lot of difficulties. But in recent years, more and more investment disputes cases has been emerged. You have found that ICSID has accepted more cases, and China now also drafting its first foreign investment law. It's a very comprehensive law which is drafted by the Department of Commerce. So today, in this session, we have six speakers. And I found that we are late, since now is 10 to 3. I would like to suggest maybe everyone will have 15 minutes. Do you think is it enough? Or if you don't mind, we only have everyone 20 minutes. 20 minutes, okay, so I give you enough time, okay, to present your ideas, okay. So the first speaker is Professor. I don't know whether my pronunciation is correct. Fauchald, right?
Yeah.
Fauchald, almost. Yeah. Okay. Okay. The topic is why is China involved in field treaty based investment disputes? Welcome.
Okay, thank you. Actually, we will present together. So we are two presenters for one topic, and we will stay within the 20 minutes. So that saves you a lot, the 5 minutes for all the others. So our question is why China is involved in so few investment disputes, and we'll go through this with you. We have this initial slide which just shows the investment disputes that in which China has been involved so far, 3 on inwards investment and then 6 on outward investment. And we'll propose for you to divide the history of Chinese involvement in investment disputes into 2 main periods. The first period being the period marked by narrow dispute settlement clauses in this treaties, and as we've heard earlier today, this was a very widespread practice of China in the 1980s and 1990s. There were also some treaties that totally lack ISDS clauses. There were 4 such treaties, 2 of which are still relevant, the ones with Romania and Turkmenistan. We have then an additional 84 BITs that China entered into with narrow dispute settlement clauses. Not all of them are equally narrow. There are 8 clauses in 8 treaties that are somewhat broader than this expropriation amount of compensation for expropriation that might be interpreted a bit broader. But essentially, all these 84 treaties are with narrow dispute settlement clauses. So the first BIT with a broad clause came in 1998, but nevertheless, despite this being a feature dating back to 1998, we argue that there were still almost 10 years in which we could say that the Chinese BITs were essentially dominated by the narrow clauses, and there are several reasons for this. The first is that most of these treaties had also a narrow MFN clause. This is a rather technical issue how you define a narrow MFN clause, but the point here being that the MFN clause is very closely associated with fair and equitable treatment. So it refers back to fair and equitable treatment, which means that it would, in our view, then not apply to access to jurisdiction. So not on the jurisdictional issues. Then we had why 2006, 2007? Well, the major reason here is that we did not get any decisions on these narrow dispute settlement clauses until 2007. So in 2007 we had the Lindmark case, which kind of set out that these clauses could be interpreted as also including whether or not there had been expropriation in these cases. So you could make a claim based on this kind of a clause. It was not in a Chinese treaty this case concerned, but the case was then about a similar clause under a Belgian-Luxembourg treaty. The language being approximately the same that you found in the Chinese treaties, and the same interpretation was then confirmed again in relation to a Chinese treaty in 2009, the first Chinese investment case, which was brought by Chinese investors. By 2007 there were 18 treaties with broad ISDS clauses, of which 5 had been enforced for more than 2 years. So there were hardly any treaties with significant investment or potential for disputes that were enforced by 2007. And we've also argued that both arguments associated with the availability of investment treaty texts and the number of BITs that were enforced at the time are arguments that points in the direction that China were making these treaties mainly as part of a diplomatic effort of relating to countries rather than really aiming at protecting investor rights. It was not the main purpose of these treaties to protect investor rights. It was mainly a diplomatic effort at least from the Chinese side, and probably to a large extent also from the other side. So we argue that this changed in 2007 or around that time, and it became commonplace to expect dispute settlement under the narrow treaties with narrow clauses, and then you got a proliferation of treaties with broad clauses. And the status as of 2017 is that we have China has this kind of treaty relationships with, and now we're only talking about treaties in force. We have these kind of relationships with 111 countries plus 2 countries where there is no ISDS clauses. So we take those out, Romania and Turkmenistan we take out. Then we have 111 countries left. We have 60 of these with narrow clauses, and we have 51 with broad clauses. We have discussed a little bit earlier today where to put Australia in this, and some argue that Australia should be put in the category of narrow clauses. We have put Australia currently in the category of broad clauses, but we'll reconsider that classification. We have, when it comes to dispute settlement, we have 6 cases under the treaties of narrow clauses. 1 concerning inward. Here we have, we can see the cases. The red ones are the ones with narrow clauses. So we have 1 on inward investment, that is a narrow clause case, and we see almost all of the outward cases are under treaties with narrow clauses. So there has so far hardly been any cases under the treaties with broad clauses, and that's kind of puzzling in a sense. We come back to that issue later on. But we see that after the Tsai-Yap-Shung case, which was the one Chinese case that marked that these cases could be these clauses could be interpreted also to cover expropriation, the question of expropriation, then other investors have followed suit and made claims under these treaties. And we've also discussed the Sanam case a bit earlier today, so we know a little bit about that case. We have also then gone through what could be expected. I mean, if we take these treaties with narrow clauses, I think we couldn't reasonably argue that we should expect more cases appear under these treaties, because the treaties remain fairly limited. What you can claim under these treaties, at least it's limited to expropriation, and we know that the issue of whether you can get decided the expropriation issue in itself is controversial, and that it's likely to be challenged. It's likely to take a long while before you get the final answer. So this issue remains problematic under the treaties. And there are also other reasons why we wouldn't expect there to be more cases. We come back to that. And then we have gone on with this puzzle of why are there not more cases under the treaties with broad in ISDS clauses. So that's kind of the core issue. That's the remaining issue. In this period from 2007 until 2017, that is when we would say that there is a low number of investment disputes in which China is involved. So we can isolate the issue to that period and to the treaties with broad investment dispute settlement clauses. And if we compare China to the other countries with approximately 51 BITs in force, we see that China is fairly low on the list. But there are other countries that are equally low. It's Belarus, it's Morocco, it's Iran, and then China, who has those countries have approximately the same number of disputes. So well, it's not decisive, and we see that the number of disputes among these countries with approximately the same number of treaties in force vary very significantly. The average time of being in force of these treaties is 10 years. So that would cover the whole period, but of course there are a number of these treaties have been in force for a shorter period than 10 years. For example, the Australian treaty was entered into in 2015. That's one of the most recent treaties to enter into force. These treaty partners with broad clauses, they are mostly high-income countries. 41% of the partners with which China has this kind of treaties are high-income countries in the World Bank index or the World Bank classification system, which should, in a sense, count in favor of there being more disputes. And if we look at the average number of disputes of these 51 countries, it's 14 disputes on average between these countries. So that should also be an argument in favor of the number of disputes that involve China is a low number. Then I think I've used my 10 minutes, and I hand the floor over to Fredrik.
All right, so continuing to explore the question of why there haven't been more cases under these broad treaties, we have also done some empirical research into economic data. According to the cataloging of the official Chinese statistics on FDI, China has 161 investment partners in total, as you can see. By contrasting 2012 investment data showing the stock FDI by origin and destination with our own in-depth cataloging of all of China's agreements that are in force, we are able to see how much of China's inward and outward FDI stock is currently protected by investment agreements and to what extent. So this data is all based on the World Investment Report's data, which again is copied from official Chinese statistical yearbooks. As we can see here, approximately 20.8% of the FDI stock in China in 2012 is protected by broad ISDS clauses that are in force. That is approximately 280 billion US dollars. And the narrow clauses, only about 2% of the FDI in China is under narrow clauses. The lion's share is that 68.3% of the FDI in China is totally unprotected by these investment treaties. That is about $917 billion. Because of the statistics only showing a certain amount of countries, 8.9% is also unspecified, so we don't know exactly whether these are protected by IAs or not. We also know that Hong Kong is a very substantial investment partner. As you can see, if we take Hong Kong entirely out of the equation, the FDI protected by broad clauses is instead 37%, which means that Hong Kong FDI into China is a very substantial part of the investment. And those numbers also represent the change after removing Hong Kong from the equation. Looking at the outward FDI stock for the same things, we can see that 17.6% of the FDI going out of China, the stock, is protected by broad ISDS clauses. Only 6.5 again is under narrow or under clauses that don't give any right to ISDS. And finally, 75.7% of the FDI is totally unprotected by any II in force at all. And you can see again the numbers for Hong Kong, which are substantially very different if you remove Hong Kong from the equation. So overall, this would indicate that a very substantial amount of the FDI going in and out of China is unprotected, which could help to explain why there have been so few cases where China or Chinese IAs have been initiated. Of course, these findings can't be very conclusive, because the fact that $1 is catalogued as FDI coming from one state does not mean that in the context of IAs it cannot be considered as an investment from other states as well, which is especially interesting for Hong Kong. Again, this data is based on 2012 FDI stock data, which to our understanding is the latest available stock data. So we would welcome, if anyone knows where we can find more recent data on this, we would highly welcome any input on that. Next up, we've also looked at the sectoral distribution of the FDI. I will present our research into whether the sectoral distribution of FDI could provide any indicator as to why there are so few cases based on these Chinese investment treaties. So for the inwards FDI, we were also not able to find any stock data. So we chose to use FDI flows to find the main sectors of FDI going into China. So the specification of primary, secondary, and tertiary sectors here is used in order to be able to compare with the database of existing investment disputes by the United Nations Conference on Trade and Development, the UNCTAD. So as you can see, the lion's share of the investment going into China has historically gone to the manufacturing sector, which contributed to the most part of the which received most of the FDI. But in recent years, the tertiary sector has been getting a lot more of the FDI. We have chosen to put real estate in here, and real estate has always been a very important sector for receiving FDI in China. Comparing these numbers with the UNCTAD database on the 817 known investment arbitration cases, we can see that 14% of the cases involved investments in the manufacturing industries and only about 5% in real estate. We do need to look more into the details surrounding the sectoral distribution of inward FDI before we can make clear indications. But as of now, our preliminary research suggests that the sectors that receive the most inward FDI stock in China seem to be sectors that statistically have less investment treaty arbitration. We've also made a similar analysis for the outward FDI, but for this we have the stock data from 2016. Here we can see the FDI stock originating from China and the distribution of the outward FDI stocks between the sectors. the primary sector of FDI going out of China. The FDI going out of China that goes to the primary sector abroad receives 12.3% of the total stock. Manufacturing receives only 8%, and the tertiary sector receives 79.7% of the FDI going out of China. Looking at the UNCTAD database on most known investment arbitration cases, we can see that 16% of the cases concern mining and quarrying, 8.5% concerned financial and insurance activities, and wholesale and retail 5%, whereas leasing and business services 11.2% of mining, 35% at leasing and wholesale business, and 12.4% at wholesale and retail trades, and finally 13% at financial intermediation. So based on what sectors have historically seen more disputes in the UNCTAD database, it would seem that around 35% of the outward FDI stock is going to industries that quite frequently face investment treaty arbitration disputes. This finding indicates at least that Chinese investments are among the types of investments that more frequently end up before ITA. We've also located a bit of a puzzle for these cases that we looked at before. 6 of the 9 cases are initiated under IAs with narrow ISDS clauses. And as we just saw, only 2% of the inward FDI stock and 6.5% of the outward FDI stock originates from and ends up at jurisdictions that have investment agreements with narrow ISDS clauses. This is very strange that the majority of the cases initiated under Chinese ISDS clauses are initiated under narrow clauses when such a very, very small percent of the total FDI is actually going into such clauses. And finally, we try to locate some other explanatory factors for finding out why there haven't been more cases initiated under these broad ISDS clauses. And when we look at the treaties with broad clauses, we can see that almost all of them, or actually all of them, that have broad clauses also have, as a pre-dispute requirement, administrative review procedures. I think the Chinese pronunciation is something like 行政复议 or something like that. And we think that this may be a major factor for disputes regarding the inward investments. Based on our preliminary research, it would seem that there are many things about this procedure that would be attractive for a foreign investor because it's a requirement that they have to go through it anyway. And some might find that they, even after they go through it, they might not need ITA anymore. Second, there's a cooling off period in almost all of China's BITs and IAs, which when you combine this with China's preference for non-confrontational dispute settlement, this could be a factor because this cooling off period is mandatory. So it would seem reasonable that the Chinese government would use this as a chance to try to make a settlement that is agreeable without using ITA. Some of the IAs also have a temporal jurisdiction limitation, so that after a certain time limit you cannot bring the case to ITA, but this is only present in a few of the IAs, so it probably isn't a very significant factor in explaining why there haven't been more ISDS cases under the broad IAs. We are also exploring if other means of dispute settlement could be explaining why China is not more involved in ISDS. And we have especially looked at the domestic courts, where we know that there is a very substantial amount of cases every year that involve foreign parties. Also, commercial arbitration could be taking over for a lot of the ITA cases, but of course China as a state would not be party to those arbitrations. Finally, we think that there might be a chance that the existence of corruption or bribing in relation to an investment might be causing both the investor and the authorities to have an interest in avoiding publicity. And ITA would, of course, bring that kind of bribing or corruption to light, which would not be in anyone's interest. And also bringing a claim before ITA would definitely be a loss of goodwill in the eyes of the Chinese authorities, which could be another reason why the non-confrontational settlement of disputes would be favorable for the investor. That's all I've got. Thank you.
Thank you for your valuable presentation. Since you are the jointly presentators, so you use 25 minutes. Okay, I give you 25 minutes. And I think this is a very interesting and valuable topic. And the presenters tries to explain why with the rapid growth of FDI in China, and we have more than 130 BITs, but we have less cases for the investment disputes cases. We only have 9. Among the 9 cases, 3 relating to the Chinese foreign investors, Chinese investors, right? And for the Chinese the government, and the 6 relating to the Chinese investors. They try to explain the reasons why, and give us the statistics, and also give a very detailed analysis on the reason. Thank you very much for your presentation. And the next speaker is Professor Liyu from Renmin University School of Law. His topic is China's foreign investment law at a crossroads, new challenge. Welcome.
Thank you, Chair, and thank you, faculty of Copenhagen College of Law and University of Copenhagen, and thank you, Joanna. This is my second time to visit Copenhagen, and I like Copenhagen very much, especially the snow in the winter. Today, I will make this presentation on behalf of law school's postdoctor Li Fenghua. He wrote this paper for the conference based on my proposal and based on our discussion. But what I talk about may be a little different from the paper. It's this morning, Professor will talk about many people talk about China's leadership in international rules making, and President Xi also called Chinese people to make further contribution to the global community. But I'm thinking, what kind of contribution to make to the community, especially in international investment law area? So I'm thinking about what measures have Chinese government already taken to reflect this ambition and to realize this dream. And we know just last year, American government and the EU, both of them published reports about China's AME's issues related to AME cases in the WTO dispute settlement system. And both reports made commentary on Chinese foreign investment law. So let's see what kind of Chinese measures Chinese government have already taken. My presentation covers this kind of topic, issues. First, I'll give you a background, and second, from the international perspective, what the rules of international law played in these areas, and then we look at what current issues from the domestic issue, and fourth, what kind of measures or proposals for reform, and then lastly, I'll give you the current situations of Chinese government measures. First, let's look at these slides. In these slides, I give you some resources, main resources of China's foreign investment laws. Here, there is a constitution, and there is a law on Chinese foreign equity joint venture. This law was adopted in 1979, and before the current Chinese constitution. And we notice that it was revised mainly in 2001 and 2016. So from this, I divided the Chinese foreign investment laws into three categories or three generations. First one is the equity joint venture law. At that time, there is no current constitution. And this current constitution, there is a provision about foreign investment. This was adopted in 1982. In 1978, there was no contract law in China, no property law in China, no limited liability corporation governance, but we have a equity contract, Chinese foreign equity joint venture. There we have a corporation law, we have a contract law, we have a liability corporation structure. So we notice that in that time, Chinese government voluntarily, unilaterally open Chinese foreign investment market to foreigners. This is the key important. I call it, this is the first generation. Second generation, from Chinese enter the WTO, the period. In 2000 and 2001, Chinese legislation, NPC, revised Chinese foreign investment laws, including joint venture law, contractual venture law, and wholly foreign invested law. The purpose was to make Chinese laws, domestic law, to comply with China's commitment and the WTO rules. So China's enter into WTO law. Usually we talk about its trade measures, but in fact, from the influence on the China's foreign investment law, it's a big event. From this on, Chinese domestic law tried to keep compliance with international standards, international law standards. And in fact, there is a case that is a Chinese publication case. There is a dispute between China and the American, and Chinese government amended its law according to the finding of the WTO-GSB. So this event reflects the Chinese attitude to international law. And also, we talk about the Belt and Road Initiative. In fact, just as Professor Hu talked about, in China, this was a hot topic, and some scholars proposed that there should be a unique dispute settlement applicable to one belt, one road areas. But also, we are talking about what's the difference between this dispute settlement and the others. For example, the WTO dispute settlement, the RCSID, and the New York Commission arbitration, and so on. At last, most of us realize that we should not recreate a special dispute settlement system, but we should use the current system to serve the Belt and Road Initiative. This illustrates that now Chinese government pay more attention to international development, international yields, and also pay attention to our domestic affairs. So now, what kind of situations we have in Chinese foreign investment laws? We have many laws and regulations and measures. We have 5 laws concerning foreign investment, and including joint venture law, contractual venture law, wholly investment law, and partnership law, and cooperation law. And we have several regulations promulgated by State Council, and we have many regulations and measures, opinions, decisions promulgated by several departments in charge of this kind of series. Though I taught investment law in China at our law school for 2 decades, I was still confused by the rapid development and the rapid changes of this kind of measures. So now we are face the situation of fragmentation of law. So what measures we will take. And we noticed that in recent legislations, NPC, it seems to me the Chinese government appeared to take a rather new approach to international law. There is no this kind of provisions in this kind of laws concerning the relationship between domestic law and international law. And this reflects a concern of the Chinese government. That is that the application of international law may hurt the uniform application of domestic international law. So, what kind of measures we should take? Now, we face this kind of challenges. At first, I talk about that fragmentation, and also we face the situation, the balance between protection and openness. And now, many talk about that, whether we should close doors to foreign investors, whether we should pay more attention to our industries. This morning, Professor talked about the Chinese agricultural commitment. In fact, Chinese culture's commitment in the WTO is a bad case for many Chinese scholars. They think that the commitment was too broad. So now the Chinese relevant government or department agencies worry about the new openings, new commitments, whether they should make new commitments or just stay the same level as the WTO commitments. And also, we faced a new situation, that is, many people think that now China has more foreign currency reserves. There is no need for foreign capitals. So, the two reports of EU and the US governments also expressed the concern that they think that the foreign investment are less welcome. And the perception is that the Chinese government take more measures of protection. Another element is that the Chinese government now is streamline administration and try to take negative list to govern Chinese domestic issues. And lastly, as we talk about that, there are many BIT between China and other countries, and China now have more and more outbound investment to other countries. So, what kind of position should Chinese government take, domestically or internationally? So, there are many proposals. Because of the time limit, I just tell you what kind of measures Chinese government have taken. This is the reason why I call it now we have a third generation of Chinese foreign investment law. In 2011, NPC made a decision to suspension of several provisions of foreign investment laws and established a pilot Shanghai Free Trade Zone. Now we have 11 this kind of FTZs. In these 11 pilot FTZs, we suspended many provisions of approval provisions concerning approval. Just like here, for example, printing, business, civil related activities, certification, entertainment. So, when US government and the EU in their reports express their concern, I want to say that, in fact, we should pay more attention to Chinese government's reforms. We should have positive. We should have confidence in Chinese reform to keep the foreign investment market open. And now we have two kind of, according to Chinese laws, current Chinese laws and regulations, we have two kind of foreign investment enterprises. First one, the kind not subject to approval. just a fine record. So I think compared to 1979's legislation, now Chinese laws change a lot. They abolished many approval provisions. So we should notice this sign, this positive sign. And another foreign investment, it is still subject to Chinese government approval system, that is the approach of negative list. We also notice that this list is becoming shorter and shorter. And the market open to foreign investment is become open and open. So I think at the crossroads, Chinese government have taken a positive measures, give us a more confidence and give us a positive sign to foreign investment laws reform. Thank you.
Thank you, Professor Han. You used 20 minutes. Okay. And Professor Han recorded the legislative development of Chinese foreign investment law, and also mentioned the main challenges that Chinese foreign investment law are meeting now, and try to give the possible solutions and the reforms to the Chinese foreign investment law. Thank you very much for your presentation. And the next speaker is Professor Julien Chaisse. I don't know what is the pronunciation. Is it correct? Okay, thank you. And he is a professor from Chinese University of Hong Kong, and the topic is China in International Economic Dispute Resolution from the Investment Disputes Resolution Perspective. Thank you.
Thank you very much for this kind introduction, and thank you very much to the organizers, in particular Joanna, for putting together this fine events. I'd also like to apologize for my outfit. The most casual speaker today. It's very embarrassing, but the excuse is that British Airways lost my luggage somewhere in between Hong Kong and London. So I'm before you, as I've been traveling a bit earlier. I had many things to say today about China and investment disputes. But in fact, as you have seen, I already skipped a few slides for the sake of time, actually dealing with the classic issues of ISDS and Chinese involvement. And the reason is that many things have been said, and very nicely said earlier in this session, and even earlier today by Professor Vivian Bath. I had still a few more comments to make, but I'll do this in the Q&A a bit later today. What I thought is good for me to focus on, in fact, is an issue of investment that we have not discussed yet in today's very rich presentations and discussion. And in short, this is the issue of the role of the GATS, so one of these WTO agreements, the one that deal with trade in services. So, of course, some of you may say, well, that's the session on investment, not trade. So why do you bring us back to trade while it's investment? Well, precisely because even if that treaty, even if WTO is supposed to be about trade, well, there is a number of WTO rules that are in substance about investments. And to come to the point, the General Agreement on Trade in Services is one of these treaties and set of rules which in effect deals more with investment than trade. And that's why, in my view, it has to be considered as an investment treaty. And I think I'm not the only one, because a few weeks ago, someone like Adlung from WTO published a very short and sharp note in the Columbia FDI series entitled "The GATS, the Investment Agreement that Already Existed," or the multilateral agreement on investment that already exists, which is already available. So let me justify this just a bit further. There is nothing groundbreaking in what I'm going to explain. The GATS overall deals with trade in services, that's a fact, but as some of you may know, there are different modes of supply of services. There are exactly 4 modes of supply. The modes called the mode 1, 2, and 4 are essentially about trade, but the so-called mode 3 is about investment. So let me just zoom in on this so-called mode 3. The mode 3 is defined in the article 8D GATS, which says that it relates to any type of business or professional establishment through 1, the constitution, acquisition, or maintenance of a juridical person, or 2, the creation or maintenance of a branch or a representative office within the territory of a member for the purpose of supplying a service. So there are many things that I should comment on here, but the basic idea is that once the WTO talks about any type of business that can be constituted, acquired or maintained as a juridical person in China or by Chinese companies in any other WTO members, that's investments. So here, again, what I'm saying is not groundbreaking because that's been known for many years by a number of trade diplomats. They knew that when they negotiated the GATS and when they crafted this Mode 3, they were dealing with issues of investment. They were dealing in particular with issues of market access with regard to investment in the services industry. That's a very important caveat. Here I'm not telling you that the GATS Mode 3 covers all and any type of foreign investment. It only addresses these investments in the sector of services. And that is something very important, I think, because the GATS Mode 3 already provides for a certain degree of market opening, let's say liberalization, for a number of WTO members with regard to investments in the services economy. So just to explain you perhaps a bit more carefully the type of investments or investment scenario I'm talking about, the best way to do is to say that this Article 28 GATS can be given, some shape or reality with an example. And a Mode 3 example would be when the provision of financial or banking services by a branch office of a Japanese banking operating within the territory of the United States is rendered by this subsidiary. This transaction, or more specifically that very fact to invest in the host country in order to supply a service, is the commercial presence, is the investment. And this is what the WTO is going to facilitate. So here I need to go a bit beyond the Article 28 that you have here. The Article 28 basically simply provides for a framework to identify the type of transactions which are subject to the GATS. This is it. Now, what we need to look at is a bit more technical, and these are the commitments that each member is going to take with regard to the GATS Mode 3. So it means that here, the Mode 3 design applies across the board to all WTO members without any exception. They have all agreed on this concept, and they have agreed to facilitate Mode 3 investments. However, the extent to which each WTO member is going to liberalize is going to be different. Here we deal with something that trade lawyers call the asymmetry in the liberalization under the GATS, which is something perfectly possible. Each WTO member is going to decide to open up the market to a certain extent. Some are going to heavily liberalize, some are going to liberalize a bit less. They are going to provide this kind of different approaches in their commitments. So you may say, what's the point here in relation to the investment discussion? Is it that we can predict some investment disputes at WTO dealing with Mode 3 commitments or China and the other members? Yes, of course, but again, there is nothing new here. Many people have talked about this for many years. We haven't yet have any Mode 3 related disputes for a number of reasons. I can come back a bit later on this, but it doesn't mean it's impossible. And my take is that the Mod 3 commitments and the likely disputes that could arise from this WTO provision is likely to increase because of the accession process. And here I need to relate what I already discussed, the Mod 3 commitments, and its relevance with regard to investment disputes, to something that's a bit unnoticed, the fact that a number of countries are in the process to access the WTO. You have the list, which is comprehensive, exhaustive, on the screen. There is almost 20 countries that are trying to access WTO. So they are different stage, they have different chances to do so on the short run. But that's not the most interesting. What I want to do here is perhaps try to surprise you a bit and say, look, there is here a direct connection to something that no one has so far discussed, which is the relevance of WTO law and the GATS Mod 3 in the context of the Belt and Road Initiative. Because if you carefully look at the list of countries that really want to join WTO, half of them, those in red, are Belt and Road Initiative countries. So you know that the list of BRI countries is not closed, not official, but here I find that there is something very interesting. Azerbaijan, Belarus, Bhutan, Bosnia, Ethiopia, Iran, Iraq, Lebanese Republic, Syria, Serbia, Timor-Leste and Uzbekistan are all part of the Belt and Road Initiative. And as we know now very well, many of them are not bound to China via investment treaties, so there is no investment protection. And in addition, as it was explained by Jacques Chiang a bit earlier, the Belt and Road framework is not a true framework because there is no overall treaty that applies to it. But my point is that WTO plays a very important role, or I should say has the potential to play a very important role. In order to understand this, we need to understand that I need to discuss the fact that in the context of the Belt and Road Initiative, if China lacks or is not in the position to negotiate new investment treaties or new FTAs with so many partner countries, well, China could be using the WTO accession process in order to impose certain obligations on these candidate countries. By this I mean, instead of getting, say, a treaty with Azerbaijan, a trade or investment treaty, well, what China should be doing now is using the accession process to ensure that Azerbaijan open up its markets to Chinese investors in the service industry. And that makes a lot of sense when you think about infrastructures, banking, telecommunications, and so on. What I find to be also important to mention is the very process of the accession process, because many people usually think that at WTO everything is multilateral, which is wrong. So I cannot go into the details of the accession process. You have here just a snapshot of Azerbaijan and where this country stands now in terms of accession. So first, it's a long process, but the most important here is that you have different tracks, and you see that there is a multilateral track that involves all WTO countries at the same time, but in parallel, Azerbaijan, as all the acceding countries, will have to negotiate bilaterally with selected countries. And here it would be very interesting for me to see how China is going to approach this. I think that China, at the bilateral level, should in fact carefully look at the commitments that are going to be made by Azerbaijan and all the other BRI countries that are in the process to access the WTO. And that's very important because we know now very well that the accession package can result in very expensive obligations. It's been the case for China itself. In short, China, when accessing WTO, has agreed in a number and a type of obligations which are more significant than all the historical members. And what I think here could be a very interesting paradox is that at its turn, China could use WTO membership to ensure that the BRI countries that are not willing to negotiate investment or trade agreements beyond WTO agree within the WTO framework on obligations that are going to serve the purpose of the Belt and Road Initiative. This is not science fiction because in fact, I've talked to a number of diplomats involved in the accession process of a few countries, not all the BRI countries, but Azerbaijan, for instance, reporting to me that yes, as a matter of fact, the Chinese negotiators have already begun to talk about a number of commitments that they expect in some sectors, and that they believe could favor the development of the Belt and Road Initiative. And what I find very interesting here is that, surprisingly, what China is using is not just investment treaties or trade agreements, but also the whole framework that's been in place for quite some time, the GATS and the WTO, but this time for its own benefit. And that's something which I think it's really worth discussing and further researching. Of course, in the paper I'm working on, there is more than that. We will need to discuss the type of obligations, both general, specific, that are part of the GATS regime, and compare that to the investment treaties to see where there are overlaps, what are the pros and cons of one and the other. But I don't have the time to discuss this. Just in short, of course, even if China were to secure significant commitments, liberalization and further commitments on the part of the BRI country via the accession process, which in my view wouldn't be a surprise, there is a major caveat, which is the dispute settlement mechanism. We would then have to rely on something that's state to state and not investor to state dispute resolution. But we have learned from the past that it's not something that make the WTO useless. Right? There is a number of cases that have had a considerable magnitude and that were filled at WTO. Let me also add that just a few months ago, India took the initiative to file a WTO claim dealing with Mod 4 commitments, something that was seen also for many years as a bit science fiction. Many people saying, well, the Mod 4 commitments dealing with the temporary movement of personnel, of workers, is not something that can give rise to WTO disputes, but this has happened. So I don't see why we could not have WTO GATS Mod 3 disputes involving China as a claimant against a number of BRI countries WTO. I think it's something which is worth researching. So I come now to the conclusion in, let's say, perhaps two parts, two very quick points, so as to make sure I make it within 15 minutes. As I said, I had more things to say about investment treaties and ISDS. But let's say in the conclusion, what I gather from many different presentations that were made today is that for a number of reasons, China involvement so far is very, let's say, minimal, could say disappointing. But it's also something that would require further reflection. What is the chance given to China, given this fact that it's not fully absorbed, fully committed by ISDS as it is now? And that I think quite interesting, because on the one hand it means that China may have a card to play to participate in the reform of ISDS, although we don't know yet what's China's position vis-a-vis the international court system notion and idea. But somehow the feeling is that China is coming with a fresh eye and a limited exposure to investment arbitration, which gives it some kind of legitimacy to participate in the reshaping of the world system. While at the same time the BRI is going to unfold, we are going to see more and more Chinese investments in BRI countries. And as far as ISDS is concerned, I think that's going to be the real taste for the existing Chinese investment treaties, at least the third generation treaties that have the potential to protect Chinese investments abroad, and we will then see whether we get an increase of ISDS in that context. I think this is what's already going to show whether these treaties have the potential to increase Chinese involvement in the whole regime. And the second point to conclude here is perhaps a bit more conceptual, but I think again worth sharing with you. What's behind the GATS Mod 3 and the process of accession is also the old idea that we should not distinguish between trade and investment. So I'll say it's an old idea because trade and investment are the two sides of the same coin. because many have argued for many years that we should not have BITs that isolate trade matters from investment issues, but we should rather have FTAs that both regulate trade and investment. And you know that's the story of the old navigation treaties that only later on were split into two types of legal regimes, which are not satisfactory. And what I find very interesting is that in the recent months, China has shown a great commitment to WTO, its rules and its dispute settlement body. And in addition to what I've said on the GATS Mode 3, I think it's also worth mentioning the very important role that China played in the G20 over the last year, in particular 2016, 2017, when China was chairing the negotiations, and China could, with the other G20 member, obtain from these negotiations a set of principles that you may have heard about, the G20 guiding principle on foreign investment. And it's interesting because it's the very first time the G20 went into issues and debate of investment as opposed to trade. For the last 10, 20 years, the G20 was only meeting to talk about trade. And I think it's not a coincidence, under Chinese presidency, the G20 got some soft law guidelines on foreign investment, which also perhaps mean that China is working on ensuring a greater convergence of trade and investment regimes. I will leave it here because I think there is much to discuss, but I hope you will be interested in these few comments I wanted to make in that session. Thank you very much for your attention.
Thank you, Professor Chaisse. And it's also a very interesting topic. GATS actually is a trade issue under WTO. However, the third mode, the mode 3, commercial presentation, is also kind of investment. However, the disputes under the GATS will be normally is between the WTO members, is the public body. However, under the BIT investment treaties, the disputes normally is between the sovereign states and foreign investors. But now we know that trade and investment has very close relationship, especially in the free trade agreement. Trade and investment normally combined together. Okay, it's very difficult to draw a very clear line between the trade and the investment, especially in recent years in the free trade agreement. Thank you very much for your presentation. And the next speaker is Mr. Hu Bing. He is an assistant professor from Beijing Foreign Studies University. And the subject of his presentation is immunity from jurisdiction and the dispute settlement, a perspective of Asian infrastructure investment bank.
Yeah, thank you.
Welcome.
So good afternoon. Second, Joanna and Peng offering this opportunity for me to present the IFB topic here. Asia Infrastructure Investment Bank has been the focus worldwide since its initiation in 2013. So I will narrow my topic to this one. In order to be a international organization that's carrying on the financial cooperation smoothly, IFB's immunity position should be respected by member states. That's one perspective. The other perspective is that in order to guarantee or secure the IFB project affected people's right to a fair trial, IFB should build a kind of dispute settlement systems. So there is a balance between immunity and dispute settlement. So that's my focus of this presentation. First, I will talk a little bit about, update you about the present situation, the status quo for IRB. Just yesterday, it was the second anniversary of the IIB's opening up for reform. So far, AIB has member of 84. It has 57 founding members. It has increased a lot. I guess 4 rounds of member increase. So now 84 members, including 23 prospective members. AIB is not a dispute settlement body itself. AIB is doing infrastructure projects to connect the world, to connect Asia. So that's its major job. So far, AIB has 24 projects, has approved 24 projects, and totaling 4.2 billion US dollars. So that's means something, because among those 24 projects, 23 are within the Asia areas, and the one project is located. The 24th is located in Egypt. It's considered as kind of non-regional country project. And coincidentally, those 24 projects are all within the Belt and Road Initiative countries. But AIB is not created for Belt and Road Initiative. That's for certain. So far, AIB legal framework is essentially in place, centered around the Articles of Agreement, and its procurement policy, its environmental social policy, its financing policy, its prohibited practice policy are all in places. So this is the governance team of the IIB, and here is the structure. So it's a kind of it looks like a little bit complicated, but so it's very, very lean. As IIB President Jing Liyu promoted the modus operandi as lean, clean, green. The first word is lean. It should be a small staff, and with very skilled small staff. So IIB as international organization, it has a full personality. This is agreed within IIB's Articles of Agreement. It has a full jurisdictional personality to make contract, to acquire property, to institute legal proceedings, and to take other actions. So this is agreed among the 84 member states. And this international organization, while it's international organization is initiated by China, and its current president is Chinese. It's headquartered in Beijing, China. So unavoidably, this institution has Chinese elements. I cannot say it's with Chinese characteristics, but it's with Chinese elements. China has veto power officially, or in principle, it has veto power. China has over 30 share stock holding in that institution. As a voting power is 26%. So it has a veto power over the most important items in decision making. But China committed a kind of a consensus principle in practice rather than using voting power to decide things. So that's very, very much Chinese, very much the Oriental rather than Western style. Some observe that it's kind of informal culture. Well, it's kind of a mixture between consensus and vote. Actually, Professor George Jackson has talked about this decision making in the WTO settings. So either consensus or vote doesn't work in practice. So there should be kind of you find the right place in between. I have a paper published with the GEO called Chinese multilateralism in the IIB. Well, at the opening forum of the IIB 2 years ago, Chinese President Xi Jinping called the IIB as kind of a platform, a new platform to build a community or shared future for mankind. This is the kind of top-tier motto of China's foreign policy. And actually, since its initiation and through the 2 years operation, the IIB is kind of an international organization that is pro-developing countries. Is developing in the project allocation, in all kinds of issues. So it's committed to be pro-developing countries. IIB also hold this already very closely called a wide consultation, joint contribution, and shared benefit. This is well known in China because it's also a principle of a Belt and Road Initiative. But people also talk about the relation between IIB and the Belt and Road Initiative. That they same, IIB solely serve the Belt and Road Initiative? No, they have two different functions. They have overlapping, as I said, the 24 existing projects are all located in along the Belt and Road Initiative countries. But IIB may extend its projects to like Latin America, to Africa, to all kinds of, actually all the member states are qualified in principle. There is, as President Jin said, all the IIB is open and welcome on the projects initiated by BRI countries, only if those projects are qualified, meet up with the IIB standards. So that's also one kind of a perspective to observe the two institutions' relationship. Well, this kind of background, IIB as international organization. As I said, IIB, when it needs to fulfill its purpose and carry out its functions, IIB needs to be protected by the immunity from jurisdiction. This is the principle enjoyed by every international organizations. And in theory, a little bit of theory, the immunity from jurisdiction applies very widely, like in legislative and judicial and enforcement actions. And international organization immunity develops, as you know, from state immunity. And it generally evolves from kind of absolute immunity to restrictive immunity. It means in some kind of extreme situations, the international organizations, including IIB, its immunity can be waived. It can be sued in domestic courts. So, in my paper submitted to this conference, I categorized the four kinds of immunity situation. That's called scope of application. The immunity of the bank as an organization. But there is exceptions. When the bank is doing commercial transaction, its immunity is waived. That's a kind of a recognized principle. Immunity of bank personnel. Bank personnel, when that bank personnel performs acts in official capacity, the bank rather than the bank personnel, immunity should be waived. Third kind of immunity is immunity of bank property and assets. The fourth one is immunity of bank archives and documents. And the fourth one enjoys the highest level of immunity, almost absolute. So this kind of four scopes of application of immunity that I elaborated in my paper. Well, these four are not mutually exclusive. They can be closely related. I give example here as a civil liability in road accident caused by bank staff, like IIB staff in Beijing, and at the bank, the IIB, not the staff, should waive its immunity from legal process. But and the bank assets may be executed for the satisfaction of judgment. So I say the four types of immunity situation can be closely intertwined. Well, this immunity, as I said, evolves from the absolute to restrictive immunities. There are cases that are challenging MDB. MDB means Multilateral Development Bank, including World Bank, IIB, and some other regional developing banks. So I listed 5 cases that involves challenging to MDB immunities. The first 4 happened in U.S. domestic courts, and the 5th is a late 26. It took place in Supreme Court of Canada. So they are all cases that involving the multilateral development banks. In those kind of cases, IIB immunities are challenged by private parties. By private parties, but generally, in those cases, the MDB's immunity were held firmly. Well, so summarize those cases. We find the situations which are subject to the challenge from private parties, they include employment disputes, environmental social complaints, MDB's role in procurement process, deficiency in MDB's dispute settlement systems. MDB sometimes often publish the section's decision, and this can also bring cases against themselves. As MDB, when doing also cooperate with local jurisdictions, this can also bring cases against them. Some of those situations already has cases there. Like employment disputes, there is a Mandora case in U.S. court here in the second case. In the cooperation with the jurisdiction, domestic jurisdiction, there is a case called Wallis case in Canada, 2016. So some other situations may be subject to challenge, but so far there are no cases as far as I research. Well, in the context of this situation, the IIB's immunity keeping being challenged, MDB's immunity keeping being challenged, MDB should at the same time not compromise, not take advantage of its immunity. It should guarantee the MDB provide affected private parties' right to a fair trial. This is also very important for MDB's image, for its reputation. So, MDB should establish adequate dispute settlement system within themselves as necessary complements or counterbalance of its immunity. So this is different from what Professor Hu advocated. It's different perspectives. It's kind of a dispute settlement system built from within. And this is a tradition from the World Bank since the end of World War II. So this kind of dispute settlement systems has the following 3 features. First, it's they are averse to strict judicial type law application. MDBs generally do not like to do formal dispute settlements. But during developing of their own dispute settlement systems, these systems themselves becomes more and more judicial type in terms of independence of the adjudicating party, in terms of 2-tier appealing system building. Well, second, MDB provide different dispute settlement forums for different subject matters. I already shared with you that different situations where dispute settlement may come from. So for those different forums, there are different dispute settlement systems. There are some situations like commercial transaction. The arbitration provision is written in the law, in the rule of the MDB, but in practice, it's almost always resolved through negotiation. So that's unique to MDBs. I summarize the following quite numerous dispute settlement forums, including accountability mechanism, sections regimes, and some other dispute settlement forums. You see, there are commercial transaction disputes. There may be investment arbitration issues, but they all apply to those 4 features, 3 features I said before. This paper I recently published with Hong Kong Law Journal, so I will not elaborate more. And in this presentation, I I just want to look into the first dispute settlement forums, like accountability mechanism. Generally, accountability mechanism refer to the complaints from local people who are affected by MDB finance projects. Those projects generally implies involuntary resettlement and human rights violations. So those local people complain to the MDB, say your staff violates your rules and procedures. You should take care of this. So this is the accountability mechanism. This mechanism investigates whether MDB staff fulfill the obligation to comply with the bank rules. So it's kind of fact-finding body. World Bank started this mechanism in 1993. That's the first one. And EBRD, ADB, IDB, and all other kinds of MDBs follow this suit. World Bank has inspection panel. This, as I said, this is a fact-finding body. It reports to the board of directors rather than to the president. So this kind of independent from the president and from its working team. It has a number of cases on its website, and the inspection panel publishes judgments, orders, publishes and analysis. So this can be a kind of valuable source of precedent. It's a new rising law departments for the academics. This is a process. This is a process how the World Bank inspection panel processes work. It finds the facts whether the MDB staff comply with its rules and procedures, and then it gives its investigation report to the board, and the board will come back to the management, and management will take the corrective actions. So this is generally the working process. Well, now let's come to AIB. I talked about MDB in general, and now let's come back to come to AIB accountability mechanism. Well, AIB prioritize a credible accountability culture. It's a 2-year-old institution. It values its culture building very much. This not reflects in the IIB Articles Agreement 26, Article 26. It's also reflecting IIB's Environment Social Framework, paragraph 64. And this mechanism is under construction so far. As I said, IIB's legal framework is essentially in place except for this major one. So far, it has finished its first round of public consultation. I personally participated in this public consultation by submitting one of my papers and for 4 proposals. And now its second round of public consultation is to start soon. And upon the approval of the board directors, this accountability mechanism, I guess, this year can be put in place. So this is the article published with the journal World Trade. I put forth 4 proposals for the AIB accountability mechanism. First one is AIB should start with a kind of ad hoc panel of experts rather than a permanent like inspection panel like the World Bank. Then after 3 years, it can be developed into a permanent one. Second, its a relationship with the general counsel under the management should reflect, should avoid a dual position of general counsel acting as counsel both to the panel and the back management. This was, I consider, this was a kind of a demerits of the World Bank. AIB should avoid this. And the third, to demarcate complaints by demarcating responsibility. This institution, this mechanism should only deal with the issues that are solely responsible, solely for those situations that are AIB staff should be responsible. It should not deal with the situations that the borrowing state, where borrowing state causes problem. So that's going to demarcate complaints by demarcating the responsibility. Third, should encourage early solution at all phases of those working with dispute resolution process. Should offer opportunity for consultation between affected people and AIB for early solutions. So this is for efficiency of the project. So AIB's purpose. And just to conclude, AIB has kind of a high standard international organization. It should maintain its immunity on the one side. At the same time, it should build a very fair and efficient dispute settlement systems. Only by with these two perspectives taken care of, then the AIB can really fulfill its purpose. Thank you.
Okay, thank you, Professor Gu. Give a very interesting topic, and mainly focus on the AIB. And as an international organization, enjoy the immunity from the jurisdiction. And my personal understanding is that immunity from jurisdiction really refers to the immunity from the domestic cause jurisdiction, like the sovereign state and the other international organization. And another part of his presentation is about how to build a disputes resolution mechanism inside the organization, right, to resolve the relevant disputes among the members of the AIIB or the I don't know whether my understanding is correct. Maybe this is also a question to you. After the presentation, you can make an answer. Okay, thank you. And the last speaker is Professor Delei Peng. His topic is the other side of the coin, in search of the foreign investors' obligation in international investment law. Professor Peng is from the East China University of Science of Technology in Shanghai. Welcome.
Okay. Thanks for the chairperson, and thanks for the invitation from Copenhagen University for giving me this chance to share my recent research. So just now our chairperson introduced me. I'm from China, and currently I'm the researcher at World Trade Institute in Switzerland. So today my topic is about the other side of the coin in search of foreign investors' obligation in international investment law. So as we know, in international investment system, there are two parties, generally speaking. One of them is foreign investor, and the other side is home countries. So this research mainly focuses on foreign investors' obligation. So here is the outline. This research contains 4 sections, and behind each section there is a small question. For example, section 1, the introduction and the background. So it tells why I'm doing this research. And for the section 2, the sources obligation for foreign investor. So I try to find the obligations for the foreign investor. So for section 3, I will go you some recent development in this area. And finally, is the implication means what's the implication for China? How about Chinese China's history? So it is the whole picture. So the second point 1 is the background. So why I did this research? So this picture indicates the Chinese foreign direct investment flows in China and abroad. So we can find clearly from this picture, in 2015, there is a change point. And in 2006, we can find actually the FTI flows abroad actually over the flows in China. So it is a big background. And the question is, I want to ask myself, are all these investment responsible and sustainable? Actually, it's not. So this picture tells us, in recent 10 years, what are troubled transactions of China's overseas investment in Belt and Road countries. So I don't like to go detailed the information. So we can find here not only state-owned enterprises but also private sectors. You know, when they do the business outside, actually they meet a lot of troubles. Yeah, meet a lot of troubles. So not only like energy sector but also like transportation sectors. So that's the things we have to consider for Chinese government and Chinese investors. And the phase 3, so the phase 1 and phase 2 are just from the investor's perspective, and the phase 3 and phase 4 from the host country's perspective. So we can find actually in recent years the changes in national investment policies. So we can find that two lines. One represent the liberalization, and the other represents the restriction. So we can find clearly, actually in recent 5 years, the restriction measures are increasing. Yeah. And it is the detailed information. For example, in 2016, we can find the restriction measures is nearly means new restriction measures nearly reached 10.2. It's higher than previous years. Yeah. So this phenomena we must be clear. So that is tell you why I do this research. Yeah, do this. And the second point is about the sources of obligations for foreign investors. So means what are the obligations for the foreign investor? So I try to find the obligations from 4 different perspectives. The first one is a domestic perspective, just like Professor Han discussed with us. And the second is BIT, we call it bilateral investment agreement. And the third one is free trade FTA or RTA. And the final perspective is international soft law, like from the UN perspective and the G10 team. So the first thing in this section, the first thing I did is try to find all the domestic law. Yeah. So I summarized here. For example, in these domestic rules, we can find the foreign investors' obligations when they do business in the local countries. So I divided them into the Belt-owned countries and the non-Belt-owned countries. So for example, like in COVID investment law in 2013, so it regulates like the accounting and financial disclosure responsibility for the foreign investor. And like the Egypt investment law, it regulates the CSR, we call it corporate social responsibility for the foreign investor, and other obligations like fiscal obligations. Yeah. And the first obligation, like compliance with domestic legislation and the employment requirement, and the labor rights and the standards, and the environment protection and the public health protection. So that means many local rules, especially in recent 10 years, they pay more attention to the investors' obligations. So this is from a domestic perspective. So I will go a detailed example like the Mongolia investment law. So in Article 7, it incorporates the rights and obligations of investor. For example, means all the foreign investors have to ensure that the products produced and services provided like comply with national and international standards. And also they have to respect the national heritage, customs, and the tradition of the Mongolia. And another example is last year, the Lao People's Democratic Republic investment law, it also incorporates the environmental obligations for foreign investors. So it is from a domestic perspective. And the second perspective is from bilateral investment treaties. So I find like very special SADC, we call it Southern Africa Development Community Temple. So we can find clearly from this model BIT, in part 3, it incorporates rights and obligations of investors. Like, because the time is limited, I will give you some example. Like Article 10, it regulates the common obligation against corruption, and environmental and social impact assessment. Yeah, means investor or the investment should make the environment and the social impact assessment before the investment. And other articles like Article 17, it regulates the investor liability independently. Yeah. Article 19, from Article 19 to Article 22, all these articles are the obligations for the foreign investors. Yeah. And the third perspective is from FTA or RTA perspective. So here I take China as example. For example, in China-Switzerland FTA, so in the preamble, it says like that, means not only Chinese government or Swiss government, but also the investors have to comply with the CSR, corporate social responsibility for sustainable development. And China-Australia FTA also has some articles like nothing in this agreement should be construed to prevent a party from adopting or enforcing measures if the government want to protect human and animal or plant life. So, yeah, I think it's very similar with the Article 10 in WTO agreement. And China, South Korea also have the similar articles and requirements. And finally, another good example is about the CPTPP, because we know United States withdrew from TPP. So last year, the CPTPP was reached last year. So it also focuses on the members and the investors' obligations on labor and environment standard. Yeah. It is about the environment. And the final perspective is from the international soft law. For example, the UN, United Nations, issued principles for responsible investment in 2016. So in these principles, it has 6 principles. For example, the principle 1, it requires the institutional investor to incorporate environmental, social, and governance issues into investment analysis and decision-making process. Yeah. And another example is about G10. I think some of our colleagues have talked about this. So in G10, it also issued G10 guiding principles for global investment policy making. So actually it has 9 principles. So I just selected 2 of them. So for example, in principle 6, it requires all the governments have to have the right to reaffirm the right to regulate investment for legitimate public policy purpose. And the Article 8 also means when investor do the business, it has to be responsible as sustainable. So, and the next section is about the recent development in this area. So in this section, I will go to a classic case. The first one is related to the environment. Is Wetland for versus German. I think some of you may know this case. And the second case is Philip Morris versus Uruguay. It is about the healthy issues. So all these 2 sensitive dispute is how to deal with the confliction between foreign investor and host countries. So when safeguarding the public interest, the legislator is obligated to strike a proportional balance between the public interest and the individual interest of the owner. So that means maybe the arbitrator, when they decide the similar cases, I think they will pay more attention to the public interest. And another is about the security. Yeah, security. So for example, in the Canada and Cameron BIT, in the Article 15, it also have the similar articles to regulate the safety. And here is another job I did in recent months. Means I find all the BIT in different countries that have EHS articles. Like for example, the US BIT with other countries, the Japan BITs with other countries, and the Canada BIT with other countries. So it find that more and more BITs incorporate EHS articles. Yeah. So that means it is there are the obligations for foreign investors. And finally, I will share some implications. Means how about what's the story about China? As we know, the Belt and Road Initiative was proposed in 2013. So we can find actually it is I think everyone is very familiar with this picture, the first picture. And in this initiative, there are a lot of projects. However, when Chinese government or Chinese investor, when they do the business outside, they have to consider the main risks. For example, this was done by Chinese Research Institute. It is about a 2017 report. So we can find a lot of risks like political and labor issues, corruption, and environment issues. Yeah. So I think it is a good thing for Chinese government. Based on my observation, recently Chinese government takes some measures to meet this trend. For example, in 2017, the Chinese government issued measures like further guiding and regulating the outbound investment direction. So in this direction, the Chinese government asked Chinese investors have to comply with the local rules and international laws. So that means for Chinese investors, firstly they have to comply with the local rules and international obligations. And thirdly, you can find in recent years not only Chinese government but also Chinese enterprises to promote the responsible investment in Belt and Road countries. For example, every year the Chinese government will issue the report or sustainable development report, and like for the investor like China Chamber of Commerce of Metals, they will also issue the social responsibility report every year. So you can find it on the website. So I think it's a good thing. And finally, I want to say, during the construction of One Belt and One Road initiative, maybe we need to transfer our focus from project-oriented to rule-oriented. Yeah. Also, I think the China is a good for Chinese government because we can find in recent 2 years, the Chinese government issued 2 regulations. For example, it also asked the Chinese overseas investor to comply with the relevant treaty provision and other international practice. Yeah. So all this content is about my recent research, and thanks all again. Yeah. Thank you very much.
Thank you, Professor Peng. Deliver a very interesting topic. I think how to balance the interest between the host state and the foreign investors is the core issue for every arbitration tribunal when they deal with the cases. So this is, I think, is a very valuable topic. Thank you very much for every speaker. And now it's open for the questions. I think today we have, in this session, we have 5 speakers, so the audience can raise no more than 5 questions. Okay?
You should be careful with the computer because I think.
Oh, yeah. Professor Xiong.
If I may, Maxim, I'm doing my PhD at the University of Copenhagen, and I think that I will start with well, basically I have one question to the latest presenter, Professor Peng, and as long as the topic of investor obligations forms also part of my own research, I'm very interested how you define your scope, the scope of your research, in the sense that do you consider much how they work in practice, how they find their application in the actual ISDS cases. And the thing is that it looks like despite these 50 shades of different formulations of CSR clauses countries tend to include in the investment agreements, it's not much coming into actual practice. The reasons could be again different. Maybe it's just time has not come. Maybe these clauses do not work. Maybe they don't pose any type of hardcore obligations on investors, in the sense that the typical CSR clause countries strive to promote CSR obligations among their companies, and then essentially doesn't mean anything in terms of law. So that's the definition of your scope. That's the question.
Okay, thanks very much for your question. Firstly, I agree with you. Maybe it's very hard to define the investors, foreign investors' obligation, especially like the corporate social responsibility. So that is why I say it actually a soft law. Yeah, but as I know, I'm not sure in Egypt or Indian domestic law it asks the foreign investor means every year you have to download some money to the community. So I think in this sense maybe it's have like legal binding or something. Yeah. Okay. Yeah. Thank you.
Thank you very much. I have a question for Professor Gu. Regarding the legal framework, you say is in place and probably is being considered. Well, my question is whether the AIB will institute any laws or regulation for the protection of investors, which has teeth. Like something like what the ECT has. And you're saying that basically those rules which are in place are administrative in nature. By being administrative, do you mean that they're internal administrative, or they're sort of being administrative in nature? You're saying that the IEIB is more like a government agency, like type of the 行政复议 or 行政决定, which is appealable to the court, So that I have some questions. Thank you for clarification. Thank you.
Thank you for Mr. John's question. So actually, you give me an opportunity to clarify, expand a little bit on this topic. I say this is not typical kind of a dispute resolution. It's a dispute resolution system built from within to deal with like employment disputes, to deal with the bank staffs, the project affected people's complaints against the implementation of the IIB rules and procedures. Also, deal with other subject matters. This is essentially kind of administrative. Anyway, it's moving. We look at the World Bank's practice in the last 70 years. It's moving from kind of non-administrative to judicial end along the spectrum. I say it's judicial because the judicative body gets permanent as inspection panel of the World Bank in dealing with dealing with the complaints from the complaints with the environmental social implications, and it's got two-tier appealing systems like in the sanctions case. The sanction case refers to the cases that were in the procurement of the projects where IIB World Bank funded those commercial enterprises bribed or do fraudulent practice. So they may be complained. Then maybe this kind of clues or information may be submitted to the AIB, and maybe start the dispute resolution systems. And the complainant, the enterprise and individuals can be respondent. They can appeal this along the system. It's kind of administrative. This is what I said. It's kind of self-built-in dispute resolution systems. I want to expand a little bit on the. This is the very. I know it's hard, at least within China. Quite a few scholars are advocating for the building of a kind of a exit type dispute resolution system by the IIB. Well, so far, I'm quite certain IIB is not ready for this. It's not ready for build a kind of a exit. Exit or exit. IIB is not ready for this. But if you look at the history of the exit under the World Bank, we find the World Bank. Why the World Bank or exit or the IBRD developed this investor state dispute resolution center? Because it wants to promote private investment in the developing countries. So in 1966, that exit institution was finally established. Well, to mobilize private capital has always been the mandate of the MDBs, and AIB also take this as its mandate. One of the three priorities on IIB is to mobilize private capital. So if you observing from this perspective, I am also very I would say it's possible for the IIB to do a kind of exit system in the future as a kind of mechanism to mobilize private capital along the Belt Road and countries. But it should be like I guess within 10 years this possibility doesn't exist. As President Jin said yesterday, for this at this second anniversary, he said IIB will focus on its major business, that is financing products, rather than doing some other thing that is not immediately relevant to its present focus. But it's possible in the future. So thank you.
Thank you for all the distinguished speakers and the audience, and thank you for your presentations and questions. Thank you, everyone. So now I announced the second session of this afternoon is successfully over. Thank you.